can be seated. The matter before the court is Tiffany Vargas versus Riverbend Management. This is Cumberland 23-249. We are being recorded both by video and audio and streamed live on the web. I would ask counsel to identify yourselves if you would go to the podium and do so for the record in this matter. First for the appellant.
My name is James Clifford. With me is Andrew Cotter, my law partner, and we represent the plaintiffs' appellants Tiffany Vargas and Erika Acevedo.
Good morning. I'm David Goldman. I am representing the appellee Riverbend Management, LLC.
Thank you. And Mr. Clifford, if you are ready to proceed, we'd be happy to hear your arguments.
Good morning, and may it please the court. I have reserved 3 minutes for rebuttal. The issue in this case is about whether a public accommodation employer, that is Riverbend Management, is vicariously liable for the discriminatory acts of one of its employees, Andrew Mosley. This really comes down to a single legal issue of whether Mr. Mosley was acting within the scope of his employment. If he was, Riverbend is vicariously liable, and as the trial court said, he was not, and we're here to challenge that, and we believe that the facts in this case, the critical facts, support this court vacating that decision. The critical, undisputed fact here is that the trial court found that Mr. Mosley did, in fact, use a highly offensive racial slur directed at the plaintiff appellants on August 16, 2020. That has been established. That is not being challenged here. The next set of critical facts, also unchallenged, are what Andrew Mosley was doing when he used that awful language toward the plaintiffs. What was he doing when he said it? The trial record confirms, the briefing supports it. Andrew Mosley served the plaintiffs iced coffee. There was an interaction with them, brief interaction, where he directed them to go back around the drive-through window. The plaintiffs, as they were waiting to do that, somebody else helped them. And about, a minute later, Mr. Mosley came outside, no more than 10 feet of the drive-through window where plaintiffs were parked about 15 feet ahead of that. Mr. Mosley came out, brought a bag and a drink, served another set of customers who were waiting for their order. The plaintiff appellants yelled, "Have a nice day, Andrew," and he yelled, "F you N-words," and we all know what he said. This occurred 10 to 20 feet from the plaintiffs, 5 or 10 seconds after delivering that bag of food to the other customers. That is not in dispute. That is what happened. If we're not sure about what he was doing, then you can ask, well, we did at trial, ask Mr. Leidick, who owns Riverbend Management, and he's twice testified on cross-examination that in his opinion, what Mr. Mosley was doing at that time, he characterized as really bad customer service and unacceptable customer service. That's on the record, he said that. That should have been enough for the trial court to find that he was doing his job, which was customer service, serving customers, and as he was doing that, he discriminated against the plaintiffs. But he didn't, the trial court did not do that. The trial court did find, again, that he used the N-word, that the conduct violated the Maine Human Rights Act, but there was no vicarious liability because he was, quote, too far off the reservation, not actuated by a purpose to serve the master.
Well,
That is
the green
incorrect.
light's on. So are you arguing that no reasonable fact finder on these facts could find for the employer? Or are you arguing that the court used the wrong test? And if he used the wrong test, what was wrong about it?
Thank you. This is not a factual issue. This is not a clear error standard.
You just listed all the facts, and you said that under these facts, a reasonable jury fact finder should find for you. What was wrong with the test that was applied?
That is the only issue before the court, is the legal application of the doctrine of vicarious liability. The trial court used the restatement second, coupled with the law court's decision in 2009 of Dragomir versus Spring Harbor Hospital, in saying the test was whether the employee was serving the purpose or actuating a purpose to serve the master. It's outdated. We argued in Rule 59 and in this, before the court that the appropriate standard was within the four corners of the Maine Human Rights Act. You didn't need to apply tort or agency law to this case. Section 4553 of the Maine Human Rights Act states that an employer is liable if the employee is acting in the interest directly or indirectly for the employer.
Can you be specific? What was the conduct of the servant? What conduct are we talking about? Are we talking about delivering food to the other customers? Are we talking about his words at the time? What is the, boil it down to the essence? What's the conduct we're talking about?
Well, using the N-word directly at customers of public accommodation. That's the
conduct that's the
discriminatory
issue.
act. Yes, and he did it while he was performing his job duties.
Oh, slow down. So you're saying if someone is doing what they're supposed to do for a job, if they're a street sweeper, say, and they, well, use inappropriate racially disparaging language that would satisfy the statute, that the fact that they're doing something at the same time sufficiently hooks those two together to produce liability under the Maine Human Rights Act?
Yes, I do.
Okay, all right.
And if you look at Dragomir,
So you're going away from not only the restatements second, but also the restatement third, then?
well, our argument has been all along that under any of those standards, he was acting within the scope of his employment.
Well, but even the restatement third, which arguably broadens the scope a little bit, still talks about it not being within the scope of employment if it incurs within an independent course of conduct not intended by the employee to serve any purpose of the employer. So if you go and do something that is not intended to serve the purpose of the employer,
Well, the
even if
restatements,
you're at work while you're doing it.
certainly. The restatement third states, before that section, what you're talking about, 707B, 707A states that the employer is acting within the scope when performing work assigned by his employer or engaging in a course of conduct subject to the employer's control. That's what he was doing. He was performing customer service duties. To answer your question specifically, a
Well, at that
course
point,
of
was he
conduct
performing
is two or
customers?
more acts.
At
Excuse
that
me.
point, was he performing customer service duties? He had delivered the food to another customer. He is walking back into the building. He responds to an entreaty that's made by a former customer at that point. He was no longer waiting on that customer. He simply responded to a salutation, if you will, that was provided by Ms. Vargas. So was he in fact engaging in customer service?
When he issued the racial slur, he was in the middle of performing his job duties. There's no timeout where he acts in the interest of the employer 1 second and then doesn't another second. That's what the defense is contending. Under that standard-
Didn't you say a couple of minutes ago that the course of conduct we should be focusing on is the racial slur itself?
Not for purposes of vicarious liability. He issued the racial slur. That is undisputed. What was he doing when he issued the racial slur? He was in the middle of performing his job duties.
But under your formulation, what you're really saying is if anybody commits a tort essentially while they're at work, as long as, they're basically at work doing it, the employer's going to be liable. In other words, under your formulation, if somebody is checking somebody out at the grocery store, and they don't like something that the customer says, and they jump across the conveyor belt and pound them. Is that still within the scope of, they were working, they were serving the customer?
An intentional assault on a customer while he was performing his duties, I would say, is within the scope of his employment.
That's a strict liability rule. That's saying
Yeah.
if X, Y, and Z are present and A occurs, you're responsible regardless of any other factors, as long as you're within that scope of time, place, and manner to take a.
Well, the defense is contending that we are arguing strict liability. We're
Okay.
arguing statutory liability. What does the Maine Human Rights Act say?
But can I just ask, it is strict liability, isn't it? It's basic, you're saying to us, if you're on the job, you're doing whatever you do as an employee, and you do something that is an independent tort or violates the law, that the employer is automatically responsible regardless of any nexus between the job, except that they were there at the time. That's strict liability, isn't it?
Well, I could dissect that in many different ways. If the employee is doing something in the midst of performing a task, sweeping, or serving customers McDonald's hamburgers. If they're doing that, they're being paid to do that, they're on the clock, they're providing customer service.
Yeah.
And then all of a sudden, they make this hate-filled comment at somebody else, and they're doing so in that time and space within the job duties that they're being paid to do, then the employer is liable. And if you want to call that strict liability, that's okay with me.
But doesn't the law?
Other courts have said that.
So how would you define an independent course of conduct for the purposes of this restatement third? It seems to carve out something saying, if you're on the job, but you go ahead and do something that's really an independent course of conduct, that takes it out from under.
Not intended to serve a purpose of the employer.
Certainly, that's the negative, the inverse of the
Yes.
positive. But
But it's assuming that you're still on the job.
an independent course of conduct has been defined, and we briefed this in our both in the reply and in the brief in general. It requires 2 or more acts, and he's merely performing his job duties and then saying an awful thing, not off-site, after hours, on a break, somewhere else besides being paid on the job, on the clock, doing what he's supposed to be doing, and then all of a sudden veers from what he's, obviously an employer doesn't want their employee to do that. And the question really, if you think about it, is what is vicarious liability if these facts don't support it? What is?
So if he'd been
What's
on
the
a-
purpose of the doctrine?
So
He'd been on a
independent,
break,
Excuse me? I'm
if
sorry?
he'd been on a break when so he drops the food off at the car, he's now on his break time, he's sitting outside, he gets the entreaty by Ms. Vargas and then responds with the same comment. The employer is vicariously liable for that?
Well, he wasn't on a break.
Well, just answer, take my hypothetical, please.
Well, that's a key fact. He wasn't. He was working. And
But,
if-
well,
if
I'd
in
still
your
like you to answer the
circumstances-
question that was posed, thank you.
I'm sorry. If he was on a break and smoking a cigarette on the other side of the building, and it was just the 2 of them out there, and this conduct or this exchange happened with another coworker or somebody that happened to be getting into their car, then it's a different set of facts. I would think that
is that an independent course of conduct under your definition? The guy standing outside the building smoking a cigarette on a break, that's one act. You said it had to be.
If he wasn't being paid, if he was on a break, then he may not be doing
Get
his
paid,
job.
and the break time is part of your pay, it's part of your employment. So what's the difference?
The difference is, in my respect, in humble opinion and respectfully, is that the owner testified under oath that he was performing customer service when he issued this statement.
Well, no, he said that was terrible customer service.
Did.
I mean, his definition of customer service, I don't think controls our legal interpretation of whether or not he was pursuing on behalf of his employer.
I agree with that, certainly.
So you seem to be, I thought you were urging us to adopt the restatement third of agency, and that under this section, oh, sorry, I just saw the red light. Never mind. I think I was in the intersection, but I'm going to let it go. You have rebuttal.
It's a unrebuttal.
Okay.
You were in the intersection.
I know. Barely.
Good morning. May it please the court. My name is David Goldman, and I represent the appellee Riverbend Management LLC in this matter. I just want to draw your attention, because I didn't introduce him before. I have Scott Leidick with me back here. He's the owner and sole member of Riverbend Management. So this case, at its core, is about the simple question of whether traditional notions of vicarious liability are to be given effect in the public accommodations discrimination cases pursued under the Maine Human Rights Act, or whether employers are essentially, as was correctly pointed out in a number of comments up here before, if employers are essentially strictly liable for any act of discrimination committed by an employee while they're on the job. In this case, it's crucial the trial court made a factual finding that Andrew Mosley, the Riverbend Management employee at issue here, committed the discriminatory act at the center of this case as part of a personal back and forth with the plaintiffs. This was not part of any course of conduct or part of any conduct at all intended to promote Riverbend Management LLC's interests.
I see that the green light is on. What would, focusing on the facts as they happened here, what would make the employer liable under your view of principles of vicarious liability? I mean, you agree there's vicarious liability.
I agree there's vicarious liability, and in fact, the court has held that there's vicarious liability under the MHRA.
So what would, if it had happened while he was delivering her food to her, would that have made the difference to you?
It could be. I guess I've thought about this question, not surprisingly, a lot, because I knew you would ask it, or someone up here would
I
ask it.
hate being predictable.
I think that there would be a good case to be made that if back at the window when Mosley first encountered the plaintiffs, if, you know, Ms. Vargas had asked for her iced coffee, gotten it, Ms. Vargas had said, I want a cup of ice, and then Mosley says, no, go around and do it again, racist epithet. Insert racist epithet there. I think that could have arguably been as part of a course of conduct designed to promote his employer's interests, because he's trying to keep, you know, the line moving. He doesn't want to stop the line, and obviously the outrageous comment is outrageous and racist. And
So is it significant in this case, as a matter of fact, that what he was doing, although doing his work, he wasn't serving her as a customer? Or is it because he'd finished serving the other customer? I mean, what is it that?
No, I think it's absolutely crucial that he was not only not serving the plaintiffs as a customer, they had ordered, they had received everything they ordered, they had completed the transaction, pulled away in their process of leaving, and then they initiated a new interaction with Mosley here that was completely unrelated to any attempt to secure services from McDonald's. It was a factual finding by the trial court that this was an attempt by the plaintiffs to kind of goad
So, Mr.
Mosley.
Goldman, can I take you to a variation on your hypothetical?
Yes.
Suppose you're inside, he's at the cash register, there are two people in line. He's serving the first person, and he makes an insensitive racial epithet directed at the second person in line. He's not serving that person yet, but he is is he not in the course of his duties at that point? That's not an independent course of conduct, is it?
I think it depends on further context. You know, if let's say it's someone who had come into the restaurant who he knew, you know, separately, and he just saw him and just made a racist comment in that context, that might not be part of
What's the difference?
his duties. Well,
What's
the
the
difference is, and some of the cases talk about this, it's all about the intention of the person who is making the comment. So if he's trying to engage in some sort of crowd control or something like that, and, it's hard to talk about it because it's so outrageous that you would use the racist comment at all. But if part of the purpose is to keep control in his mind of the situation in a restaurant, then maybe that would be in the scope
If
of
there
his
were
employment.
excuse me, if there were a climate within the workplace of discriminatory comments being made, that in terms of the third restatement could support a conclusion that the employee thought that his comment was in some fashion serving the interests of the employer. Do you agree?
I think that's absolutely correct, and in that context, it's important to understand there was another factual finding that, my client essentially did everything he could to dissuade people from making these kind of comments, and that there was no reason to believe that Mosley would ever engage in this kind of conduct. He hadn't before. There were no reports, not only of him not making racist comments, but
And that point is well taken. We understand that. Obviously, there's no suggestion that Riverbend didn't act appropriately in this case independently, but this is not an independent liability against Riverbend. The question is vicarious liability. And by definition, really, vicarious liability can mean that the employer didn't actually do anything wrong, but they nonetheless may be responsible for the actions of their employee, right?
That is true. I do think there is an element of foreseeability that's baked into the vicarious liability analysis, but it's clearly not dispositive.
In this instance, you made emphasis upon the fact that he was delivering food to some other customers, and this was a separate conversation. But in places of public accommodations like restaurants like McDonald's, there are two classes of people there. There are the customers and there are the employees. And they interact at the counter, but when they're coming and going, they're still in that role of customers and employees, correct?
I think that's true, but in this case, not only were they going, they were essentially gone. it's a little bit fuzzier because it's not like they were in the restaurant and out of the restaurant, but they pulled up to the window, they got their food, and they pulled away on their way out. And then it was they who initiated kind of a new personal interaction with Mosley. It's not like they were asking Mosley, hey, by the way, can you now bring me some ice?
Since the hypotheticals have been flying all morning, so let me tee up another one. And it has to do with whether or not Mr. Mosley's role was to speak on behalf of the corporation. If you take a hypothetical where someone is in fact a spokesperson on behalf of the Jones Corporation, and they're addressing a large group of people, and something happens to upset them and they use a discriminatory racial epithet, does that change the scenario because their actual role is to interact and speak for the corporation?
I think it definitely changes the context substantially. I mean, I don't know how many spokespeople a corporation has, but clearly they don't have very many, and they're chosen specifically to deliver a message. In this case, if vicarious liability accrues from what Mosley did, then basically every single employee, regardless of their role, regardless of the context, whatever they do, if they do some sort of discriminatory act while they're on the job, it's vicarious liability. And as has been properly pointed out, that actually is not vicarious liability. That's strict liability, effectively.
Can I reframe this for you real quick?
Yes.
You talked about, or there's been talk about if there was an interaction between Mosley and Vargas, and he had made the epithet, used the racial epithet, that might in fact result in vicarious liability. My question is this: there was disparate service here. As I understand it, people pull into McDonald's all the time, make an order, go up and ask for some additional service when they're at the window getting their order. In this instance, his response to Ms. Vargas was, you can go through the line again. Is that disparate service now clarified by the racial epithet that was directed back at Ms. Vargas?
Well, I think that would have, for that to be the case, at least for our purposes on appeal, there would have had to be a factual finding by the trial judge connecting all these things and saying, yes, now retroactively I'm saying maybe there actually was discrimination at the present window because of what was later revealed by his intentions,
But if we're looking
down
at
the
a
line.
course of conduct, should we be looking at Mr. Mosley's entire interaction with this customer?
No, the course of conduct here, in my view, is started when the plaintiffs call out to him and say sarcastically, "Have a nice day." This wasn't a greeting. This was a factual finding that it was a sarcastic goading comment. "Have a nice day, Andrew." And then he turns, stops, responds to them in his absolutely outrageous manner. That's the course of conduct that we're talking about here. Otherwise, again, we essentially have strict liability because at some point, an employee was engaged in promoting his employer's interests during his time on the job during the day, presumably. And so if you broaden it out to say the course of conduct includes everything he did in connection with while he was on the job that day, again, you're back to essentially strict liability and not vicarious liability.
So your point is under the terms of the restatement third, he was not acting within the scope of his employment because when performing the work assigned, he was not engaging in a course of conduct subject to the employer's control. Is that where you're resting?
I don't think it's so much that he's not engaged in a course of conduct subject to employer's control. It's that he was, under the restatement third, engaged in an independent course of conduct not intended to serve any purpose of the employer. It's not so much, I guess in some sense, the employer could come out there and control a person at any time. But the question is about the intention, the subjective intention that Andrew Mosley had when he made the comment. And there is case law to the effect that, not only is that an important factor, it can be a crucial one, and it can change in a moment. It depends on what the intention of the person was when they committed the act.
I'm looking at the comment to the restatement, and it refers specifically to say, when an employee commits a tort with the sole intention of furthering the employee's own purposes and not any purpose of the employer, it's neither fair nor true to life to characterize the employee's action as that of representative of the employer, and the intention of the employee severs the basis for treating the act as that of the employer.
Absolutely, and we cited that in our brief, and I think that is the exact situation we're faced with right here.
That's what you're viewing as an amplification of that second sentence of the restatement 7.07 sub 2, where it says that the act is not within the scope of employment when it occurs within an independent course of conduct.
Right,
is
there's
that
two sides of the coin for the analysis, essentially. You know, it can be within the scope of employment in general when you're on the job, on the clock, but it's not, according to the restatement third, if it's part of,
I mean to interrupt you, but is that the penultimate issue here, whether this was an independent course of conduct?
under the restatement third.
That's the tipping point on that issue.
Yes,
Is that something for a judge to decide, or is that something that, can that go on summary judgment, or is that something for a trial?
Well, I think it can be both. I mean, if the facts were not disputed, you could decide that on summary judgment potentially. I mean, in this case, it was a bench trial, so it was the judge who decided both issues. But the bottom line is at trial, there were factual findings to the effect that it was the racist comment or the whole interaction. It's not, it's not just boiled down to the racist comment
But
taking
could
it
it,
outside the scope of
is this,
employment.
so it's a mixed issue of fact and law, so
It
it would
is.
never be appropriate for summary judgment?
Well, I think it could be appropriate for summary judgment in some cases. If everyone agreed this is exactly what happened,
Okay.
then you got facts and you apply it to the law, right? But
All right, well, that's another case for another day.
that is another case for another day, and I think a lot of the kind of how this, so I think there could be a lot of tough cases under the restatement approaches, but I do not believe this is one of them. I believe this one falls pretty clearly on the side of actions that Andrew Mosley took were not intended to serve his employer's interests, and they were entirely personal in nature, involved in this personal snippy back and forth, as the trial court found. So unless anyone has any other questions,
There
I'm
don't
happy
appear
to
to be.
sit down.
Thank you.
Thank you.
And Mr. Clifford, you reserve 3 minutes for rebuttal?
Thank you, yes. I'd like
And
to start.
that, since the green light is on, what I was starting to ask when I realized I was in the intersection there, is exactly that comment that I just quoted to Mr. Goldman, and that is that it's the employee's intention that severs the basis for treating the act of the employer as that of the employer in the interaction. And wasn't the trial judge entitled to find that when he threw the racial slur, that he was doing it because he was pissed for his own purposes as opposed to trying to further the employee's purposes at all? In other words, that it was really just solely because he was mad or annoyed.
It's a great question, and the answer is very simple, no. And the court did not consider anything about Mr. Mosley's intent because he wasn't there to testify. And there were several rulings on the record
Well,
about
they
hearsay.
don't have to, he doesn't have to testify to consider intent. We do it in criminal cases all the time.
Well, if your question is whether or not this comes down to what Mr. Mosley intended when he made the statement, and there's no evidence about what he intended or what he was thinking or what he really meant, then I think the question is what was actually said, when was it said, and under what circumstances?
What can one infer from that?
He made this comment under the restatement third, when performing work assigned by his employer, but in this case,
I don't think
and.
there's any question that it meets that test.
That's what the
first
restatement
sentence.
says.
The question is whether it's not, I think we're really arguing about the second sentence of subsection 2.
Well, there's a choice. If he committed the act when performing work assigned by the employer, that's enough. And if you want to talk about the independent course of conduct, we can, but he made this comment, as Justice Lawrence stated, after telling these people to go around. A minute later, they're standing there, and 40 seconds later, he issues says the N-word to them. That is all when he's performing customer service.
Counsel, can I take you back to the statute? You're arguing that your approach is that you want to find liability under the statute without reference to vicarious liability at common law. But the statute defines employer or any person acting in the interest of an employer. Was Mr. Mosley acting in the interest of his employer when he engaged in that discussion with?
The answer is yes, but it also says directly or indirectly acting in the interest of the employer. That's to define the
Was he
employer.
in any way acting in the interest of his employer by engaging in that, by making that comment?
With all due respect, that is not the question about whether his conduct served the interests of the employer. It's what he was doing when he made the conduct is really the question. And that is the doctrine of vicarious liability.
Thank you, counsel. As is our usual practice, we will take this matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter.
All rise.